passed away.
Oh, complainant is
Complainant
no more.
passed away
All right.
after the
Sir has come.
yeah.
Our preliminary ಏನೋ ಮಾಡ್ತಾರೆ ಆಮೇಲೆ.
So the case in criminal petition number 5529 is filed under section 438 of the CRPC for grant of anticipatory bail in respect to the same crime number. The records reveal that the police had issued a notice under section 41 capital A of CRPC on 28/3/2024 for the appearance, and accordingly, petitioner appeared before the investigating officer and thereby participated in the investigation process. The second notice of the first kind, dated 10/6/2024, served on the petitioner on 11/6, instructed him to appear on 12/6 at 10:30 a.m. for interrogation. Petitioner, by his reply dated 11/6, told the police that he would come on 17/6, he having some scheduled meetings at New Delhi. In fact, he flew to New Delhi on the night of 12/6/2024. Therefore, it cannot be said that the petitioner is not cooperating in the investigation. Sir, these are the details. Court asked, what are the details? It's a detailed order. So I'm showing the details. The learned senior advocate Sri So-and-so, appearing for the petitioner, submits that the power to arrest availing under section 41 having not been exercised, and the notice under section 41 capital A of the CRPC having been adopted consciously, and his client having already participated in the investigation process, and further assuring to participate again on 17/6/2024, police could not have secured a warrant of arrest under section 73 on the ground that the custodial investigation is necessary. Sir, kindly pause for a minute. The warrant of arrest was not under challenge. He is not under challenge either in this petition or in the other petition. As a matter of fact, he draws attention of the court to the material particulars of the case as to the incident of the offense, delay brooked in lodging the FIR, the credentials of the complainant who breathed or lost in the recent past on account of cancer, and the nature of allegations leveled against the petitioner. He also mentions about a plethora of cases filed by the complainant against others, and that they are all frivolous, as is the case against his client too. I will show not a single case was filed by her. I'll demonstrate that. Further, he also mentioned about the political vendetta. So, arguing, he seeks stay of all further proceedings. Learned Advocate General, per contra, makes submission that the petitioner is not cooperating in the investigation process. Police notice dated 10/6/2024 has been violated with no justification whatsoever. Even otherwise, custodial interrogation has become imperative. Regard being had to seriousness of the offences involved and the political background from which the petitioner hails, no interim relief can be granted to him. Mr. So-and-so, appearing for the now added second respondent in the quashment petition, also made similar submission, highlighting the recent demise of the complainant and lethargy attributable to the police in the matter of investigation. He also notifies to the court his client's writ petition number 156239 of 2024, wherein he has sought for the arrest and detention of the petitioner and for a direction to accomplish the investigation on a wharf-tea. Having heard the learned counsel for the parties for some time, having perused the petition papers, I am of the considered opinion at this stage, no case is made out for halting the ongoing investigation in crime number 84 of 2024, and that the petitioner should participate in the same by appearing before the jurisdictional police on 17/6/2024, as was assured by him. That being said, the petitioner, who is a former chief minister of the state for multiple times and who is now an octogenarian, shall not be arrested when he appears before the police and cooperates in the investigation process. Very many issues canvassed by both sides merit deeper examination. after the filing of statement for the extent. So I fail to understand whether this is a bail granted to the petitioner or a stay of arrest. What is the nature of the order that has been passed?
All interim protection.
With great respect, such a protection cannot be given in a matter of this nature,
Hmm.
which is so serious. Heinous offense is alleged against the petitioner.
Hmm.
And when such is the case,
Hmm.
without even making out a prima facie case, without even considering the balance of convenience,
Hmm.
no such order could have been made.
Hmm.
I have therefore applied for vacating it.
No, I'm
Better-
hearing it.
I maybe.
Yes, sir.
In a nutshell, if I may say so, the simple case made out in the FIR lodged against the petitioner is, I
Now
request-
I will hear him.
I,
Petitioner,
I,
not on the application, on the main matter.
And the main matter
Yes,
of this application,
On the main matter.
ಅದ್-
Yes.
ಬೇಕಾದ್ರೆ ಇದ್ರ ಮೇಲೆ ಒಂದು 2 ನಿಮಿಷ ಬೇಕಾದ್ರೆ ಹೇಳ್ತೀನಿ ನಾನು.
ಯಾವ್ದ್ರ ಮೇಲೆ?
ಇವ್ರ ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಮೇಲೆ.
That's power of the court.
ಅಲ್ಲ 2 ನಿಮಿಷ ಹೇಳ್ತೀನಿ ಇನ್ನೇನು. Well, the offenses that are complained against me is one which is made penal under section 354 capital A, as well as under section 8 of the POCSO. 354
Sexual assault.
354A, the maximum sentence that could be imposed is 3 years.
Mike,
Mike, sir.
Mike. ಕೇಳಿಸ್ತಾ ಇಲ್ಲ?
Mic on ಆಗಿದೆ.
ಯಾಕೋ
ಸಂದೀಪ್
ಸ್ವಲ್ಪ voice ಕಮ್ಮಿ ಇದೆ.
ಆಗಿದೆ.
ಆಗಿದೆ.
Mike ನಿಕ್ಕೆ.
Let me repeat, man.
Yes.
Offenses that are complained against me are one under section 354 capital A of the IPC,
Hmm.
and the other being one under section 8 of the POCSO.
Hmm.
354 capital A, the maximum sentence that could be imposed is
3 years.
of 3 years. As far as section 8 of the POCSO is concerned, maximum sentence that could be imposed is 5 years. So section 41A of the CRPC would come into play. Well, the judgments of the Supreme
Arnesh
Court,
Kumar,
commencing from Arnesh Kumar and ending with Satyendra Kumar
until.
until
Yes.
that they would say, well, the question of, and once you issue a notice under section 41 capital A, it presupposes that there is no need for the investigator to lay his hands upon the accused and to arrest him. But may I just invite your lordship's kind attention to first page of the request that is made by the investigator before the magistrate.
I'm holding writ petition 15522 of 24.
73.
Is that the one you're referring to, sir?
ಇದೆಲ್ಲ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ತೋರಿಸ್ತೀನಿ ಅಷ್ಟೇ ಇನ್ನೇನು.
ಅಲ್ಲ,
ಕೊಡಿ.
ಯಾವ writ petition?
ಕೊಡಿ.
ಇದ್ರಲ್ಲೇ ಇದೆಯಾ?
Court of Well, let's,
Yes, sir.
the investigator, in his wisdom, having thought it fit and necessary that there is no need for him to lay his hands upon me in connection with the crime that is registered against me,
Issues 41A notice.
issues a notice under section 41.
Otherwise, direct arrest. Yes.
Otherwise directly arrested. Well, I would comply with the demand which came to be made upon me to mark my presence before the investigator for and in connection with the investigation of the crime. May I just request your lordship to kindly turn to the application which the investigator himself would file before the jurisdictional magistrate, page 123. This was on 13/6.
120? Ah, yes.
123.
All right.
Would your lordship kindly turn to page 125? Well, and what he could not do for having chosen to issue me a notice under section 41 capital A, well, and he would invoke the jurisdiction of the magistrate under section 73 of the code. That is disastrous. I shall show to your lordship.
Issuance of a warrant.
Yes, my lord, why? May I just request your lordship to kindly go to page 125? Third paragraph. ದಿನಾಂಕ 6/4/2024 ಸಾಕ್ಷಿದಾರರಾದ ಮೈ ಲಾರ್ಡ್ ಗೆಟ್ಸ್ ಇಟ್
Yes.
6/4/2024 ಸಾಕ್ಷಿದಾರರಾದ ಶ್ರೀ ಶಿವಾನಂದ ತಗಡು, ಶ್ರೀ ಮಹೇಶ್ ಕುಮಾರ್ ಅವರನ್ನು ವಿಚಾರಣೆ ಮಾಡಿ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತದೆ. ನಂತರ ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಅಮಾನತುಪಡಿಸಿಕೊಂಡಿದ್ದ ಪೋಕ್ಸೋ ಮೊಬೈಲ್ ಫೋನ್ಗಳನ್ನು ಪರೀಕ್ಷೆಗಾಗಿ SFSSU ಗುಜರಾತ್ಗೆ ಕಳುಹಿಸಿ ವರದಿಯನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತದೆ. ಕೈಂಡ್ಲಿ ನೋಟ್ ದಿಸ್ 12/4/24 ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಅಮಾನತುಪಡಿಸಿಕೊಂಡ ಒಂದು ಐಫೋನ್ ಮತ್ತು ಒಂದು ವಿಮೋ ಮೊಬೈಲ್ ಫೋನ್ಗಳನ್ನು ಪರೀಕ್ಷೆಗಾಗಿ
ಅದು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
ಇದೇ ಕೊಟ್ಟಿದೆ. ಕೊಡದೇ ಇದ್ರೆ ಅವ್ರು ಸುಮ್ಮನೆ ಇರ್ತಾರೆ. ಎಷ್ಟು ದಿನ? 1 ವರ್ಷ ಆಯ್ತು.
ಎಸ್.
ನಾವು ಕೈಂಡ್ಲಿ ಕೊಟ್ಟದೆ ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
ದಿನಾಂಕ 6/4.
ದಿನಾಂಕ 6/4/24 A1 ಆರೋಪಿಯಿಂದ ವಾಯ್ಸ್ ಸ್ಯಾಂಪಲ್ ಅನ್ನು FSL ಗೆ ಮಡಿವಾಳಕ್ಕೆ ಕಳುಹಿಸಿ ವರದಿಯನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತದೆ. This would indicate that I have participated during the course of the investigation of the crime. ದಿನಾಂಕ 6/5/24 etc. he will say. Thereafter, my lord, kindly go to the next page, page 126, para 3 again. ಈವರೆಗಿನ ತನಿಖೆಯಿಂದ 1ನೇ ಆರೋಪಿತರು ಕಲಂ 8 ಪೋಕ್ಸೋ ಕಾಯ್ದೆ ಕಲಂ 354A IPC ಅಡಿಯಲ್ಲಿ ಸಾಕಷ್ಟು ಸಾಕ್ಷ್ಯಾಧಾರಗಳು ಮೂಡಿ ಬಂದಿರುವುದರಿಂದ ಮತ್ತು ಘಟನೆಯ ತರುವಾಯ A1 ಆರೋಪಿತರು ತನ್ನ ಸಹಚರಾದ A2, A4 ಅನ್ನು ಸೇರಿ ಫಿರ್ಯಾದಾರ ಮತ್ತು ಅವರ ಮಗಳ ನಂದು ಬಾಲಕ್ಕೆ ಹಣ ನೀಡಿ ಪ್ರಕರಣ ಮುಚ್ಚಿ ಹಾಕಲು ಪ್ರಯತ್ನಿಸಿದ್ದಲ್ಲದೆ ವಿದ್ಯುನ್ಮಾನ ಸಾಕ್ಷ್ಯಾಧಾರ ನಾಶಪಡಿಸದಲ್ಲದೆ ಪ್ರಕರಣ ಸತ್ಯ ನ್ಯಾಯಾಲಯದ ಗಮನಕ್ಕೆ ಬಾರದಂತೆ ಅಪರಾಧ ಎಕ್ಸೆಟ್ರಾ ತನಿಖೆಗಾಗಿ ದಿನಾಂಕ 11/6/24 ಪ್ರಕರಣದ ಮೇಲ್ಕಂಡ 1 ಮತ್ತು 2 A3 ಮತ್ತು A4 ಆರೋಪಿಗೆ ಕಲಂ 41A CRPC ಅಡಿಯಲ್ಲಿ ವಿಚಾರಣೆಗೆ ದಿನಾಂಕ 12/6/24 ಬೆಳಗ್ಗೆ 10:30 ಗಂಟೆಗೆ ಹಾಜರಾಗುವಂತೆ ಸೂಚಿಸಿ ನೋಟಿಸ್ಗಳನ್ನು ಜಾರಿ ಮಾಡದು ಇರುತ್ತದೆ. Through a notice issued to me under 41A, I was required to mark my attendance before him on the morning of 12/6/2024 at 10:30. But what I would say, kindly have a look, kindly go to page 16. But on 11/6/2024, the notice came to be served upon me. I would send a communication to the investigator on 11/6, which he has acknowledged it on 12/6. Your lordship would get, your lordship left-hand side bottom, the acknowledgement given for my communication. I am aware that I have been arraigned as an accused in the above crime number. Notice under section 41A of the CRPC dated 28/3/24 has been issued to me on an earlier date. Pursuant thereto, I have taken part in the investigation and extended my full cooperation. Another police notice was issued under section 41 capital A of CRPC to appear on 12/6/2024. The same was received by me, by one of my staff on 11/6/24. However, due to prior party engagements at New Delhi, in relation to my political party, I have left Bengaluru and as such I am unable to appear before the investigation officer on this occasion. However, kindly underline this, I would personally appear before the investigation officer on Monday, the 17th of June 2024. On 12th, he receives my communication. I have some exigencies and work in Delhi, party work. I am going there. Kindly condone my absence. I would mark my attendance before you on 17/6. But what is it he does? He doesn't wait for 5 days. But what he does is, he goes before the jurisdictional magistrate and he would make an application. But on 12/6, he would make an application on the day on which I was required to appear. By then he had received my communication also, requiring him to permit me to mark my attendance before him on 17/6. What he does, kindly go to page 127. ಅಂದ್ರೆ 41A notice ಕೊಟ್ಟರು ನಾನು ಬಂದಿಲ್ಲ, therefore issue a warrant under section 73. But when can the court issue the warrant under section 73 would be the next question. Kindly have a look at page 127.
When he is evading investigation.
No, my lord, no. Where I am absconding,
ಅದೇ absconding ಅಷ್ಟೇ.
have a look at section 73, my lord, for a second, just to refresh my lord's memory. Have a look at section 73. Warrant may be directed to any person. The chief judicial magistrate.
Escaped convict, proclaimed offender.
ಅಲ್ವೇ proclaimed offender, escaped convict. ಅವರು ಕೊಡ್ಬೇಕೇ ವಿನ, this magistrate may not, at a point of time when he accused himself would say that I don't need to arrest you.
This may be a different case.
Disastrous consequences.
Every day I am seeing cases of 73 being issued for the asking.
But disastrous consequences would follow.
The asking and proclamation being issued.